and move on to the technical, that's where we are with patents. And if you can take only one thing away, distinguishing patents from other forms of IP protection, they are for technical inventions. So patents, as I've said, protect technical inventions, and they need to be new and inventive at the point the patent application was filed. Patents are incredibly complicated, and unlike some of the other forms of IP protection that we'll talk about today, certainly trademarks and design rights, which can be fairly straightforward, patents are quite complicated, and that's because they're protecting a technical invention. And in order to protect the technical invention, you have to specify exactly what that technical invention is, and the level of specificity that is required with a patent application is very technical. So I would say with patent applications, particularly with patent applications, it's inadvisable to proceed with a patent application without seeking some specialist advice, because in doing so, you risk revealing your secret without protecting it. But I'll talk a bit more about that later. What's the benefit of a patent? Well, it gives the owner an exclusive right over the invention for 20 years, which can create a huge competitive advantage. Really, what a patent is doing is creating a monopoly. So if you file a successful patent, you have a monopoly over that technical invention, and that can be really lucrative. As I've touched upon, really, patents are granted in exchange for full disclosure of the invention. And in general, the details of the invention are then published and made available to the public. So you do have to think carefully before pursuing a patent about whether that's the right thing for you to do, and certainly you can seek some more advice around specific things that you might be working on where you feel a patent might be appropriate. But really, it's great to have another opinion around that. Patents can be very useful, but they can be a bit of a nightmare, and you need to weigh up the pros and cons of pursuing a patent before you go down that road. Interestingly, 80% of technology they believe is locked up in patents, so a lot of technology is patented. If you're thinking about filing a patent, there needs to be a clear inventive step. So you can't put two existing ideas together and say it's new. There has to be an element of invention in there. We get a lot of questions about computer programs. So if a computer program affects something in the outside world, it may be possible to patent that computer program. If a computer program is really creative, it can't be patented because there's no technical effect or outcome. And with apps, we get a lot of questions around apps as well. Often apps will be considered that they are just presenting information that already exists. And so if you're thinking about an app, a lot about what an app is creative. It's not necessarily the technical aspects of that app. And patents are technical elements, so it would have to be something very distinct and unique to be patentable. So what can a patent protect? So new inventions, how a product works, and its technical function. So what does it do and how does it do it? Again, the criteria for patentability, something must be new and novel. Really important, prior disclosure invalidates a patent application. So if it can be proved that you disclosed in any way the concept, the technical elements that are specified in your patent application will be void. And that's really important to think about, particularly if you are sending emails. So if you've disclosed particulars about something which you later intend to patent in an email, and that email is found, or somebody shows the patent office that email, your patent will be void. If you've spoken in public, if you've had conversations with people, and people can prove that they knew about your idea, it can't be patented. It has to be completely novel. It must be an invention. So as I said, it must be inventive, but it could be an inventive step. So it could build upon something that already exists, but it would have to be an inventive step. It couldn't be two things that exist together. and it must have a technical effect. So just drawing back, really, it can't be something that's purely a creative presentation. It has to have a technical effect. Really important, you must include all of the information at the point you apply for a patent. You can't make any changes or add any additional information after you've filed a patent. And I would say in the main, that's true across all IP registrations. So at the point that you submit the registration, whatever it is that you're trying to protect, be that a trademark or be it a patent, it needs to be complete. You can't go back later and say, oh, I forgot to put something in. It won't wash, so it needs to be complete at the point you submit it. The patent process, so unlike some of the other types of IP protection, which are relatively straightforward, the patent process is quite lengthy. To simplify it, we could divide it into two parts. Part one would be the patent application, patent searches and claims. So clearly you need to put a patent application together. Searches refer to the process of searching through existing patents which prove prior art, which show that your technical step isn't novel. So it's important that those searches are done. And if we think about patents and how very particular patents are, you can really get the feeling for how long a search might take, because it's very technical. Claims, so when I talk about application searches and claims essentially ring fence what is in and out of scope with your patent. And you as the applicant and the IPO may review the claims many times to ensure they're really accurate and specific. It sometimes happens in the process of writing the claims that the patent becomes so specific that actually it's no longer useful, because perhaps your first patent, your first draft of the patent is quite broad and it's infringing on other patents, or it can't be proved that what is in your patent particularly describes what it is that you've designed. It has to be very specific. After the application, the searches and the claims have been complete, you can file a patent and you'll have an A-class publication. And that would look like the patent title, the name of the applicant, the date of filing, the date of the publication, and the patent number. And that means a patent has been applied for, but it hasn't been granted. Part two is the substantive examination, and that really takes a very long time, and it can last a few years. So you'll see on the graphic I've put on the screen there, 4 to 6 years is what the IPO have indicated for the substantive examination. Now that doesn't mean your patent doesn't exist. Your patent has been applied for, it has a patent number, you can prove that you filed it and when you filed it, but the patent hasn't yet been granted. So the IPO are not yet convinced that the patent is completely novel and doesn't infringe on other patents, or people might raise issues with your patent. Just out of interest really, the shortest time, which part one and part two, so the initial application and the substantive application, substantive examination being completed, the shortest time for that would be a year. That would be in very rare circumstances when a patent is fast-tracked, when it's perhaps it's in the national interest, but usually it's going to take several years, and that's an undertaking that you need to consider really at the point you file a patent. At the point the substantive examination is concluded, you get a B publication. So moving on from your A publication, which is that you've applied for a patent but it's not been granted, the B publication includes more information about your patent, and it gives you patent granted status. So patents are really good if you have got a very novel technical invention, particularly in cases where your technical invention could be reverse engineered, and I'll talk about that a bit more in the next slide perhaps. In terms of costs, this can be a little bit misleading. So in terms of the actual costs for registering a patent, It's around £310 if you're applying online, which seems really good value for money. But I think, as I've alluded to, really, it would be ill-advised to pursue a patent without employing a patent attorney to assist you, and patent attorneys generally cost in the region of £3,000 to £5,000, and that really will depend on the nature of your application. And I would say with any technical invention, there are particular patent attorneys for particular types of technical inventions, and it's really important that you find one that has a specialism in your area. Because in order to write a patent, you have to really understand what it is you're writing the patent for, and that means you have to have a lot of expertise in that area. So if I could cite a real life example, I worked with somebody who was trying to protect an invention that was a digital invention, and it was very complicated, and the person who was applying for the patent felt that they could probably write the patent very well themselves, and I think that's probably a true statement in that case. They were the particular person who had the particular specific technical knowledge to be able to write out what that patent really was. However, and the IPO really stressed this, it's in the nuance of the way that you word things sometimes that can trip you up. And patent attorneys speak the language, and it is a very different type of thing to write. And at the IPO, when we went for this masterclass, the person who was talking to us, particularly around patents, said, "Can you write a patent?" and showed us a product, and each of us wrote a patent. And the person from the IPO went by one and really just pulled our patents apart. And okay, you know, perhaps they weren't particularly technical, but a number of the reasons why those patents that we drafted failed were because we hadn't phrased things in the right way, or we haven't been specific about the right types of things that we needed to be specific about. And it's very important, I think, with any patent that you seek a bit of technical advice and a patent attorney around filing a patent. The advantage of a patent is they can last usually 20 years if you file in the UK. The first 5 years is covered by your patent application cost, and then you have to pay to renew them every year after 5 years, up to 20 years. After 20 years, that's it. They're done, and that's because there is a finite timeline because you've created a monopoly, and after that 20 years you should have received enough commercial advantage that then that technical invention is available for the world to use and develop and commercialize, so that we don't create monopolies around technical inventions. IPO top tips for patents. So yeah, as I've alluded to, keep your inventions confidential. Any conversations, anything written down, emails sent, presentations can be held against you at point of application for a patent. It's really important to think about using non-disclosure and confidentiality agreements if you're developing any technical invention with either people inside a company that you're working with, or in partnership with others, or with third-party providers. You can search for existing and similar inventions. So just as you can search for a trademark on the IPO's website, you can do a patent search. And as I've alluded to, seek help from a patent attorney to draft your application. Patents are particularly useful for licensing, so others can make or use your ideas and pay you royalty fees. So that's a useful reason for having a patent. I think that's particularly important where perhaps you're an inventor but not a manufacturer, and you'd like to patent the invention so that other people can manufacture it, and in which case you can license out. People can use your patent to manufacture your goods. And patents really are the best protection against reverse engineering. So we'll talk shortly about trade secrets. which essentially are null and void if somebody can take apart your product and work out how you made it. However, a patent offers some protection around reverse engineering. So if you have an inventive idea and you think, as soon as I make this, everybody's going to copy it, and people in countries with very cheap manufacturing rates like China can make it far cheaper than me, and nobody will want to buy my invention even though I was the person who invented it. In that case, a patent would be really useful because you can protect the idea, you can choose to license out the manufacturing, and you can prove when other people are infringing on your patent.